Good morning. Happy hump day. For those of you who missed really cool news coverage last night, Judy You Got This reported that the court had denied Meyer's motion to modify the terms of his conditions. And Big Jim Finch posted the minute order today showing the court had denied the motion. Should come as a shock to no one. Lane Myers didn't cite any Arizona cases in support of his position that any of the conditions were violative of the First Amendment or any state statutes or state case law or anything like that. Apparently, according to Judy You Got This, who I have no reason to disbelieve, Lane's big case was State versus Elmore. I think Judy said that it was that in State versus Elmore it was remanded for an evidentiary hearing, but my understanding is that it wasn't. In State versus Elmore, a guy was on probation for like drug violations or for drug use, possession, something like that, and he wanted to go into like a drug treatment program, and he violated the rules of the drug treatment program, and because he was kicked out of the drug treatment program, they violated his probation. And the court said, yeah, we're all good on all this. The Court of Appeals did not kick it back for a further evidentiary hearing. Maybe I misunderstood Judy You Got This, and if I did, I apologize. I was only half paying attention, just kind of listening for key points in her, because she goes into it like, if you want all the little like nitty gritties, she goes into all the little nitty gritties. I'm a more cut to the chase kind of guy. I want to know like was it granted? No, it was denied. The motion was denied. I want to know the basic reasons for it, and basically it's because Lane didn't have any authorities to support his positions. And what the next procedural step is. And the next procedural step is obviously the evidentiary hearing on the probation revocation, which is not looking good because apparently, according to Judy You Got This, again, who I have no reason to doubt, the prosecution is aware of the jail calls, the interviews that Lane Myers has been doing, as one would expect them to be. Who could have seen this coming? And yeah, Lane says some pretty damning things in there. Like none of those jail interview phone calls help Lane at all. I mean, again, remember, nothing you say can be used for you, but everything you say can be used against you, and everything you said is going to be used against him. Like it's all not good. It's all not good. Anyway, back to State versus Elmore. The key holding in State versus Elmore is that a condition of probation has to be something that a man of ordinary intelligence would be able to understand. Now, obviously my position is that Lane Myers is not a man of ordinary intelligence. He's a man of sub-ordinary intelligence, and his followers are even dumber than Lane Myers is. But I think people of reasonable intelligence can understand, not just from the context of the probation conditions, but from the restraints imposed on him by the civil injunction, which I think is lapsed, but it might still be in effect. I don't know. And from the criminal protective order, the criminal injunction against harassment, I think he can infer from those that, like, you don't talk about the victim. So from those three sources, a person of ordinary intelligence would be like, you know what? If I want to keep my nose clean, because remember, committing a crime is a violation of the terms and conditions of his probation. And it is a crime to harass the victim, the protected party of a criminal protective order. And Lane Myers has pled guilty to harassment, so he knows he was harassing her by doing the things he was doing. Like none of this should be a shock to anyone, including and especially Lane Myers. But like a person of ordinary intelligence would be like, you know what? I'm just not going to talk about the person. I'm not going to say anything at all that could, in theory, get me hemmed up. That's what a person of ordinary intelligence would do, unless they really wanted to go to prison. And in that case, they would do exactly what Lane Myers has done. Because I guess Lane likes the company of other men or something. I don't know. But yeah, Elmore certainly didn't help him. Because, again, the Court of Appeals affirmed the probation conditions and the revocation. That didn't help you, dude. So that's a huge problem. In a motion, the person filing the motion bears the burden of proving the thing that they want done, of convincing the court that what they want done should be done, that what they want done is consistent with the laws, is consistent with the facts, is reasonable, is something the court should do. And if the court doesn't do it, then the court could get overturned on appeals. The burden is on the moving party. The burden is 100% on the moving party. Generally speaking, if you don't oppose, there's a high likelihood the court will just go with the moving party. But if you do oppose, then it comes down to, does the moving party carry its burden? The court will often do its own research. We'll look at the citations provided in the moving papers. We'll look at the bench guide. There's, at least in California, there's bench guides on basically everything. Bench book is, I think, what they generally call them, but they're bench guides. Like, so there's a bench guide on domestic violence. There's a bench guide on criminal protective orders. There's a bench guide on everything, pretty much. So the judge isn't operating in a vacuum, like he doesn't know anything, and he can do his own research. There's nothing preventing him from doing his own research, and a good judge probably will. I've run into way too many family law judges who don't even read the motions before they get argued, but a good judge will have read the motions. So my typical strategy, especially in family law, is to ask the court, have you read the moving papers? And if the court says yes, then I'm not going to argue the moving papers. I'm going to maybe summarize them, but I'm going to expect to get questions from the judge that maybe address things that the court wanted to know that weren't addressed in the moving papers. What about this source? What about that source? That is what an attorney is paid to do, is to prepare for these hearings, which is why on your bill from your attorney, you'll see like research. Like, he'll charge you for research. You'll see probably all the cases that he's read, all the guides that he's consulted, or she. I'm male, in case anybody was, under any misconceptions. So I'm kind of referring to me. This is what I do. This is my standard practice. And I'm assuming it's a standard practice for most attorneys, because most attorneys that I go up against on a motion hearing will have done research. I mean, you could tell by the way they argue. So the way the court handled it, by not just letting Lane read his motion again, which wouldn't help the court at all, because the court's read the motion. The purpose of an oral argument is to clarify things. I read your moving papers, but I don't understand how you're dealing with X. What do you do about this case? What do you do about this? You didn't provide any like declaration or anything that addresses these facts. Something like that. So Lane should have been prepared for it, but Lane's not an attorney, despite his protestations to the contrary. And so he was completely unprepared for it, which, is expected. I believe I specifically made a video saying that Lane should be spending his time in jail doing the research and finding substantive case law that supports his position, that's on point, instead of doing jailhouse interviews. But, why would Lane listen to my advice? I'm the bad guy because I am reporting on the things, because I'm giving, legal commentary on things. Apparently I'm the cause of the problems. I'm talking about the problems. I'm not the cause of the problems. Although apparently my name misspelled, because he decided to use a misspelled version of my name in one of his video titles, is now in the amended complaint. Oh yeah, speaking of which, the motion to dismiss was resolved. The prosecution amended her complaint to be more specific in the allegations, and everybody apparently agreed, at least from the minute order, that sufficiently resolved the motion to dismiss, so the motion to dismiss isn't going to be heard. So pretty much as I called it. So yeah. So what's next? What's next is Resnick is going to make a valiant effort to minimize and obscure and deflect and try to reinterpret all of the videos that Lane Myers has done. And it won't help. The question is, will the judge revoke or will the judge modify? I think, based on assuming the jail phone calls come in where Lane Myers says he'll never, ever, 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 ever. And apparently, according to Judy, you got this, in open court, arguing his motion, Lane Myers said he'll never, ever, 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 ever stop talking about the victim and her family. That didn't appear in the minute order. I have no reason to doubt Judy, though. So I'm going to assume that he said it in open court. Add in the fact that it's recorded on a jail call, assuming that gets introduced into evidence at the hearing. I don't think the court has a lot of maneuver room to not revoke. Which kind of goes into people complaining that DirectD got bond and Lane didn't. I want to remind everybody, first of all, that Lane got an OR bond initially in his criminal case. He got an own recognizance bond. He didn't have to pay. I could be misremembering the OR part of it, but he definitely got bond. He was out. And he immediately made videos about the victim. And because he couldn't comply with the terms and conditions of bond, the court revoked the bond. That's why he stayed in jail pending the outcome of the criminal case. And then he got probation. And now it appears that he can't comply with the terms and conditions of his probation. That's why he was back in front of the judge. And so if a person is unable to comply with the terms and conditions of probation, it doesn't make sense to put them back out there so they could reoffend. It protects the defendant. Now, DirectD has apparently not exhausted his rapport with the court to the point where they think that he won't be able to comply with the terms and conditions of bond. He hasn't shown the court that he is unable to comply. So the court, you have a constitutional right to bond, but that's subject to the court's discretion on whether or not you can comply with it, whether it's a good idea to put you out on bond. And usually what the court's looking at is, are you a danger to the community? Are you a danger of absconding, not showing up again for court? So generally speaking, that first time, you're probably going to get some bond. You're probably going to do it, unless you have a history of not appearing for hearings, and the court will look at that. And maybe you missed one, maybe you missed two, and the defense attorney is going to be like, well, my client didn't have notice of them, blah, 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 or whatever. The defense attorney will try to make excuses for you, and the court may still give you bond. But like, if you have a repeated history, at some point, the court's going to be like, well, you're not going to appear, so I'm not going to give you bond. Or, you just killed 37 people on a murderous rampage. I'm not going to give you, I can't trust you to be out there in society. But the default is you get bond. On a probation violation, as I said previously, the court can give you bond, but that's not the presumption. That's not the default. You're in a different stage. You've already pled guilty. Your guilt as to the crimes is not in contention. So the court can give you bond pending the probation revocation hearing, but it's unlikely because you're there because you probably violated the terms and conditions. So if the court gives you bond again, you're probably going to violate it because you're already violating conditions. So it's much less likely. So Direct D and Lane Myers are apples and oranges. What you should get from that is that the court does give bond. And Lane Myers got bond initially. And it's up to the defendant to not violate the terms and conditions of bond and or probation in order to keep that bond. You're out on good behavior, basically. If you can't show good behavior, you don't get your bond anymore. Your bond's revoked, or you don't get a new one if they bring you in on something. You know what I'm saying? Like, that's what you should get from this. If you're wondering why Direct D, who's facing multiple charges, apparently multiple felonies, some of which are DV related, why he's getting bond, why James Freeman got bond on DV with allegations that he was armed and blah, blah, blah. It's because that's the presumption. And if they keep their noses clean, and I have no reason to believe that Freeman isn't keeping his nose clean, he's still out on bond. Ask yourself why Lane Myers got his bond revoked. Is it because the state just hates Lane Myers, who did relatively low-level shit? Or is it because Lane Myers can't follow the rules? I know Lane Myers supporters don't like the rules, but society requires rules to function. And if you play too close to the line, eventually you're going to step over it and violate the rules, and then state has a remedy for that. The state has a remedy if you violate the rules. People are saying, like, he's fighting for our freedom. Like, I don't know. I don't particularly want the freedom to harass and stalk people. That's not a freedom I'm hoping for. These are rules that have been on the books in every state forever. You don't just get to harass people. You don't just get to stalk people. Like, society would not function if we didn't have rules along those lines. It would break down into anarchy. It would break down into violence. We need those rules. Those aren't freedoms. It's not a freedom that anybody wants or need. Well, maybe you want, but it's not a freedom that any rational person would want, to stalk and harass people. And if you say he didn't do it, I want to remind you once again, he pled guilty. He pled guilty. He pled guilty. He said, I did this. I'm guilty. So I don't know why you're trying to substitute some after the fact kind of recanting that he's doing. He pled guilty. He was fully advised of his rights. He was voir dired extensively, patiently, slowly by Metcalf. Judge Metcalf, I should give him more respect. And he still pled guilty. He pled guilty. That is not a topic for debate anymore. That one is done. It's in the history books. It's done. He's guilty. Pigs Under Pressure commented that Judge Metcalf is a defendant. What? He's a defendant in Peltz versus Metcalf. A doomed case that Peltz lost. Vernon Peltz is a disbarred attorney. I believe the story, and I could be wrong, is that he was disbarred because him and his mom had been drinking and got in an accident or something like that. And his mom, I think, has like dementia or some mental instability. Maybe it was just age related. But he convinced her to take the blame when he was actually the one driving. And the state bar like found out about this and was like, no, bro. Like, that's something an attorney can't do. That's bad. And all the people who think that, like, I'm a bad guy, remember, Peltz, who is a hero apparently in the Tucson community, hangs out with Tucson police sucks. He was disbarred. That guy was disbarred. I have never had a disciplinary action. Peltz was disbarred. That's your hero? All right. A little double standard much? The guy who hasn't been disciplined or even had a disciplinary action against him is apparently the bad guy, the guy without morals or ethics or scruples. And the guy who was disbarred is the good guy? Question mark? Anyway, in that case, it was about the right to record in a courthouse. I don't know how Metcalf got involved as a defendant, but maybe it's because he's the chief judge. But the district court was like unanimously or just resoundingly no. They apparently there was a magistrate judge's order recommending the dismissal with prejudice, and the district court adopted it and wrote a decision. Apparently it's being appealed. I have no idea why they're even bothering to appeal it. I want to remind everybody that, as I stated long ago before we had case law on this, that courts are non-public forums. They're non-public forums. And you could just look at what the Supreme Court does. The Supreme Court doesn't allow electronic devices in it. If you're going to go watch a Supreme Court hearing, you get a little locker and you got to put your electronic devices in there. You take a pen or a pencil and a pad of paper in there, and that's it. You can't audio record. You can't video record. You can't even take electronic devices in there. And the Supreme Court is the ultimate court for determining how to interpret the law. There is no higher court. No court is going to tell the Supreme Court that they can't do what they're doing. And if the Supreme Court is doing it, every court below them is going to feel that they can do it. And every court is going to be like, well, the Supreme Court allows it, so let's run the analysis. Even if somehow it gets hopped up to a higher level of scrutiny, they're doing it on the non-public forum level, but let's just say that it turns into a limited public forum. Well, that's still going to be the same analysis. Designated public forum, they're never going to do that. Traditional public forum, they're never going to do it, but let's just pretend they did. The state still has an overwhelming interest in preserving the courts for the administration of justice and not for speech, to the point where any limitation on speech in the court is probably going to be acceptable. There's just no way around it. That appeal is doomed to failure. I haven't read it. I don't even need to read it. It's done. Like, you could stick a fork in it. It is done. It was done before they filed the motion, or before they filed their original lawsuit. It's done on every level. If qualified / judicial immunity / whatever immunity doesn't handle it, then it's still First Amendment basis. It's done. It's cooked. So Peltz is the hero. Metcalf, because he's a defendant, is somehow bad. He's a defendant in a civil suit that was dismissed with prejudice, and there's just an appeal going on. Somehow he's bad. But when Lane Myers was the defendant in the civil injunction against harassment case, he wasn't bad. That's weird. And I don't think he ever filed an appeal on that. I think he was going to, but I never saw an appeal on it. Maybe I'm wrong. Maybe I just didn't see it. Maybe the guys who post shit in my Discord just missed the appeal, but I never saw an appeal. He said he was gonna. He stormed out of that courtroom after losing, just throwing a little tantrum like a 2-year-old child. Didn't get his way. Didn't get the toy he wanted to play with. Stormed out. I'm gonna appeal. Speaking of appeals, the court is actually doing Lane Myers a huge favor by making sure. I think it's standard. I've never seen a criminal hearing where there wasn't a court reporter, because they're very likely to get appealed. So the court is doing Myers a huge favor by making sure that there is a court reporter in there. And again, I think it's standard. I think it's required by some rule somewhere in Arizona, because at these kind of hearings, like especially felony hearings, there's always a court reporter there, and I'm assuming that in felony probation revocation hearings, there's always going to be a reporter, but it is the court reporter's transcript, not the audio recording, that the Court of Appeals would look at if you appeal it. That's mandatory. It's necessary. I've never seen anything else at a Court of Appeals level. Like I do see like administrative hearings, like DMV hearings. I've done a couple of those. Those get audio recorded, and then if you petition the Superior Court in California for a writ of mandamus, they will use the audio. But then if it goes up from there, then you need a written transcript. So I've never appealed one, but courts of appeals require written transcripts. So, well, they only look, they're not going to play the audio. They're going to want a written transcript. So it is a good thing that there's going to be transcripts for Lane to appeal. I don't think he has any grounds for appeal at this point. I don't think he has any winning grounds, especially. But this is going to preserve his ability to appeal, and he'll have plenty of time in prison, assuming that things go the way that I think they're going to go, and his probation gets revoked. He'll have plenty of time in prison to write his appeal, and he won't have time to take hits of 35% THC vapes or whatever he was doing and get stoned in the middle of writing his appeal. So hopefully he'll have time to do proper research and prepare a proper appeal with citations to actual Arizona case law and statutes and things like that maybe support his position, at least tangentially, instead of doing that nonsense that he did, which was laughable and a joke. Anyway, I'm done ranting. Thanks for watching. Have a great day.